Can I just check, are the Opus systems?
Well, it says this is a test.
I'm going to move on to ground 2, but before I do, can I make just 2 very brief remarks, so just following up on ground 1. The first was just going back to a couple of observations your Lordship made in relation to paragraphs.
Sorry, I'm just getting my clerk to bring my glasses in.
It's all right. Do you want me to pause?
No, it's absolutely fine. Having had a cataract operation, having spent 50 odd years being short-sighted, I now have the bizarre experience of being able to see all of you without glasses on, by the way, but needing glasses to read, with comfort. So I'll be
necessarily happy about that.
No, I didn't take it as such. I can say I was going to apologise, but I thought you.
Anyway, sorry, Mr. B.
Yes, the remarks I was going to make 2 essentially. First, just in relation to your Lordship's observations about, in particular, paragraphs 476, 477 and the nature of the conclusions there. I think it is very important, the elements that your Lordship emphasised, for instance, the duration and nature of the infringement and so on, those all went to considerations of causation. When it comes to quantification, you see at 479 very clearly, having reached that conclusion on causation, we then have to place a value on the likely overcharge. In doing so, we adopt the broad axe approach. And that is where we say there's effectively a missing middle here, because you didn't properly engage with the burden and standard of proof, and as I say, without excessive precipitation, you are allowed to use the broad axe, but it's not a whole approach. And I won't go back through the intermediate conclusions on foreign exchange and global financial crisis, but what one does see there are references to the arguments, and just for your notes, at paragraph 409, where it said, well, Professor Nevin's approach, it's arguable that Professor Nevin's approach has certain problems. Notwithstanding the fact at 408 there are very substantial problems identified with Mr. Harvey's approach. So what your Lordship referred to as conclusions, for instance, at 410, we say if they're being seen as evidence that, as conclusions that the standard has been met even on a broad axe basis, those are not sustainable on the prior reasoning. In fact, we say those aren't conclusions at all. They're merely descriptive, and they do not give rise to the basis for the overall conclusions on loss that are then reached, or rather on overcharge that are then reached. But the second remark I just wanted to make in this context is, I think it's important to stress that we have emphasised in our grounds not only that there wasn't justification for finding there was an overcharge in relation particularly to the evidential position put forward on foreign exchange and global financial crisis, but we've also criticised the way in which the split has been done. We say that there isn't a proper basis for using Mr. Harvey's analysis as the top end of some kind of split. We say split is the wrong way of doing things, that's absolutely clear, but it's the wrong way to use his upper bound, or the merged upper bound of 10% as the basis for a split. He hasn't made that out on the basis of the tribunal's own analysis. And I think it's also important to emphasise that the outcome of this and the position being adopted by the appellant is not that means there must be zero overcharge. That is not the position. We recognise that you can maintain and prove certain elements that may be found by a tribunal to amount to an overcharge. I gave the example in relation to the emissions premium. And it is important in thinking about these things that one recognises that that position is one that the appellant sees as being entirely consistent with the proper approach to the analysis of the evidence. And in addition, one final point in relation to this, when we talk about the idea that somehow Professor Nevins should be used as the outlier at zero overcharge, that fails to recognise that the fundamental approach being adopted throughout by the appellant was you need to prove the case, you as the claimant. It's not on us. With those remarks, I will move, if I may, to ground 2, which is concerned with supply pass-on. And I will go back to one or two of the cases, or at least one of the cases referred to before. The 4 cases I was going to touch on are British Westinghouse, Supreme Court in Sainsbury's, the MIF umbrella proceedings, and Stellantis, with which the court has a degree of familiarity. I imagine the court may have a crying degree of familiarity with British Westinghouse, but nonetheless, if I may, Authorities Bundle 1, tab 3. As I say, you'll be very familiar with the issues about the breach of contracts in relation to defective turbines and the replacement by more efficient turbines, and whether or not those greater efficiencies should be taken into account. The passage that is cited begins at page 37. Second full paragraph on that page. The fundamental basis is thus compensation for pecuniary loss naturally flowing from the breach, but this first principle is qualified by a second, which imposes on a plaintiff the duty to take all reasonable steps to mitigate the loss. So this is the foundational propositions to do with mitigation, and only reasonable steps are required. And then if we go over the page, following a consideration of the Staniforth and Lyle case, the New Zealand case, sorry, not New Zealand case, concerning a New Zealand ship, the first full paragraph, I think that this decision illustrates a principle which has been recognised in other cases, that provided the course taken to protect himself by the plaintiff in such an action was one which a reasonable and prudent person might in ordinary conduct of business properly have taken, and in fact did take, whether bound to or not, a jury or an arbitrator may properly look at the whole of the facts and ascertain the result in estimating the quantum of damage. So this is the criterion for what counts, essentially, as falling within the scope of mitigation. Then recent illustrations of the way in which this principle has been applied and the facts have been allowed to speak for themselves are found in the decisions of Eric County Natural Gas and the Wertheim case. The subsequent transaction, if it were to be taken into account, must be one arising out of the consequences of the breach and in the ordinary course of business. This distinguishes such cases from quite different class illustrated by Bradburn and Great Western Railway, where it was held that in an action for injuries caused by the defendant's negligence, a sum received by the plaintiff on a policy of insurance couldn't be taken into account. And then the key point is the reason of the decision was that it was not the accident, but a contract wholly independent of the relation between the plaintiff and defendant, which gave the plaintiff his advantage. Now, all of those principles, very much principles the court will be very well aware of, but it's important for the purposes of this aspect of the case that we're focused on questions about whether or not there is legal causation and factual causation in relation to the issues of pass-on. With that, can I jump a long way further forward to Sainsbury's in the Supreme Court, which is Authorities Bundle 4, tab 23. This is the case I touched briefly on in dealing with ground 1, with which the court will be familiar.
Yeah.
One of the myriad of MIF cases. I won't go through the details of the description of the MIF, I imagine the tribunal is relatively familiar with how that works, nor indeed the first 4 of the 5 issues that arise in this judgment. But we go back, if we may, to page 1379 and the broad axe issue, beginning at 175. So this is all about pass-on. And in fact, this was all being dealt with to some extent in the abstract, because MasterCard had accepted that at trial it hadn't succeeded in proving that the overcharge had caused Sainsbury's to raise its prices, but nonetheless the matter was considered further. And the way in which the court approached it, described in 181, was to look at principles of EU law, and then if we go on to page 1383, looking at the nature of the claims, you see at 193, in each case the merchant's primary claim of damages is for the pecuniary loss which resulted from the breach of competition law by the operators of the scheme. That direct loss is prima facie measured by the overcharge. 194, it's trite law that as a general principle damages to be awarded for loss caused by tort are compensatory, and then we get the Livingston and Royards and Watson and Laidlaw references, and then that discussion of the US that I mentioned previously. And then if we go down to where in the US you don't have this pass-on issue because of the federal rules. It's different at a state level in the US, but at federal level, those are the rules.
Hanover Shoe, isn't it?
Yeah, it's Hanover Shoe, and although it's not referred to here, it's Illinois Brick as well. Those are the 2 cases which essentially make it possible for direct claimants to bring claims, direct purchasers to bring claims and prohibit pass-on.
To pass on is effectively raising trade actor in American law.
Yeah, I suppose that is right.
Because there's no risk of the indirect purchasers. I mean, there's no risk of the customers of Sainsbury's suing Visa or MasterCard if it were in the United States.
If it were in the United States at a federal level, yes. Yeah.
Whereas, as we all know, there's a real risk of that.
Oh yes, and that's a point we'll be coming back to.
46 million.
Yeah.
Excluding
there's no shyness in relation to the case. Yeah. No. There's going to be plenty more for the Court of Appeal on these issues, I imagine, for the forthcoming period. But let's just. Well, I'll come back to that one in a moment. 197, where it's articulated that. In contrast to the statutory scheme, or the rather judge-made scheme in the US, there are sound reasons for taking account of pass-on in the calculation of damages for breach of competition law. Not only is it required by the compensatory principle, but also there are cases where there's a need to avoid double recovery through claims in respect of the same overcharge by direct purchaser, and they refer to them as subsequent purchasers. I tend to refer to them as indirect, in a chain to whom an overcharge has been passed on in whole or part. Question then arises as to whether the merchants are entitled to claim as the prima facie measure of their loss the overcharge. And as I indicated, there was a discussion because MasterCard and Visa said, well, it's for you to prove. If we then move on to paragraph 205, this is the taxonomy of potential routes of pass-on that was developed by the Supreme Court and was fed through into the case law. In the present appeal, merchants, by paying the overcharge in the MSC to acquirers, have lost funds which they could have used for several purposes. Sophisticated retailers which obtain their supplies from many suppliers and sell a wide range of goods, they can respond in a number of ways. And so this is drawing on what the CAT has said previously. There are 4 principal options. 1, merchant can do nothing and thereby suffer a corresponding reduction in profits or higher loss. 2, merchant can respond by reducing discretionary expenditure like marketing and advertising. 3, the merchant can reduce its costs by negotiating with its many suppliers. 4, the merchant can pass on the costs by increasing the prices which it charges to customers. Which option or combination it will adopt will depend on the markets in which it operates, may be influenced by whether the cost was one to which it was alone subjected or shared. If the merchant were to adopt only option 1 or 2, or a combination of them, its loss would be measured by the funds which it paid out on the overcharge, because it would have been deprived of the funds for use in its business. Option 3 might reduce the merchant's loss. Option 4 would also reduce the merchant's loss, and then it's subject to the caveat, except the extent that it had a volume effect. In other words, if you push your prices up, then if you
might sell less.
You might sell less, exactly.
And we are only concerned with 4 in this case.
Absolutely. We're only concerned with 4 in this case, and 3 is a very different beast. Indeed, what we get from Mr. Ridyard's
Quite good reasons for thinking 3 shouldn't exist.
well, yeah, the 2 and 3 are really rather the same. I mean, this is not novel, although Mr. Ridyard puts it very neatly. As people pointed out at the time of both the CAT judgment and the Supreme Court, for many businesses, things like marketing should be seen effectively as an input or supply, just as any other supply might be. There's something very old-fashioned about the idea that supply only comes in physical form, and actually it doesn't. It comes in a range of forms, and therefore categories 2 and 3 you can think of as quite close together.
There is some discussion in the authorities which may need to be resolved in another case as to whether 2 and 3 are effectively the same and to be treated in the same way.
Yes, I think that's one of the problems with the Supreme Court judgment that doesn't arise here. But Mr. Ridyard's observation that 2 and 3 from an economist's point of view are very similar, and as he puts it, much less likely to give rise to any form of pass on from an economic perspective. I think, without in any way wanting to doubt the Supreme Court's taxonomy or its analysis of that taxonomy, I think it is going to be something that's going to be revisited, but thankfully not in this case.
One of the problems is that I think all the court was doing was reciting findings of fact made by the CAT.
Yeah.
Whether those are economically sound or not, they weren't challenged. This was just the evidence. They summarised the evidence, and the Supreme Court picked it up without critical commentary. So there's a risk in attaching too much weight to this as conceptually correct. It's just, I think, their recitation of the facts as found by the CAT, indeed, in a...
Yes, sorry, I'm not demurring and where it came from. I think it's not so much the recitation of the facts, it's what's then said about what counts, that 1 and 2 don't and 3 and 4 do. And I think it's that split that has given rise to the issue. Whereas I think, as my Lord Justice Newey is observing, 2 and 3 in many ways should be seen
the same thing.
And 4 is therefore extreme. It's a different species, effectively. Anyway, that's confirmed in 206, that how the Supreme Court dealt with these issues. If we then turn on, so we've got the mitigation and burden of proof. I already took the tribunal to 208, as I recall, which the point that was being made.
Can we focus on 209 for a moment?
Please.
Just, I mean, it seems to me to have some relevance because it applies, if you like, a standard of proof by reference to the doctrine of effectiveness, and it seems to challenge the proposition the claimant must establish a particular overcharge. To do so would probably infringe the principle of effectiveness.
Well, I think this is probably going back to ground 1 more than perhaps in relation to ground 2. But I think the very reason why we recognise that you don't apply the ordinary balance of probabilities, is it more likely than not that it is X pounds, is because you don't identify, although the court at the end lands on an overcharge, as a claimant you don't have to prove it is more likely than not that that particular overcharge is what you suffered. That is why I kept referring to substantial loss. There is a difference between identifying a causation of loss, proving substantial loss, and a requirement that you must prove an overcharge. And that is all that 209, I think, is saying. It's not attenuating any of those other principles. Sorry, my lord, I interpolated that the question was directed more at ground 1 than ground 2.
Well, it could be. When I read it, I thought this is a ground 1 issue, but here it is under mitigation. and passing on.
But it's because it's of the symmetry in approach that
yeah,
I think
yeah.
I'm not sure.
I suppose
I'm not,
the words I was really focusing on were a particular, in relation to the argument you've been making that there's got to be some establishment of proof of something quite particular.
Well, I was trying not to, it depends what particularity, of course, means, but I was trying to move away from, and it is no part of our ground one submission that you have to prove on balance of probabilities, a sort of absolute, more likely than not, a particular pound, shilling and pence. And therefore, to that extent, we don't take issue with, you don't have to prove a particular overcharge. That's entirely consistent. As I say, going back to what we were saying about ground one, we say that there is a missing middle in the tribunal's analysis that moves from causation finding that there is a loss to a quantification of a substantial loss without a proper evidential basis, saying we can do it on a broad acts basis. There is nothing in that analysis that cuts across paragraph 209 here. Then, if we pick it up just over the page at D, you see in 211 that there's a reference to the legal burden on the defendants to plead and prove that the merchants have mitigated the loss, but that in the context of these appeals, as we discussed below, the significance of the legal burden shouldn't be overstated. And then there's reference to Fulton's shipping, some discussion of Thai Airways, and indeed reference in 215 to Westinghouse, to which I referred. Because in this case, we're not dealing with what's referred to in 215 either, but 215, the Supreme Court says we're not concerned in these appeals with additional benefits resulting from the victim's response to a wrong that was an independent commercial decision or an allegation of failure to take reasonable commercial steps for a loss. I mean, we're in the same territory to that extent. And then you've got the citation of British Westinghouse and the paragraph that I've referred you to already. When in the course of his business, the claimant has taken action arising out of the transaction, which action has diminished his loss, the effective actual diminution of the loss may be taken into account. Here also a question of legal or proximate causation arises, as the underlying words show, but the question of legal causation is straightforward in the context of a retail business in which the merchant seeks to recover its costs in its annual or other regular budgeting. And this is the essence of the point that we make in relation to legal causation. It is completely straightforward in relation to this case as a category Little Roman 4 case. Then at 216,
Well, it isn't saying, is I don't read it as saying,
sorry,
that every category 4 case is perfectly straightforward and legal causation follows as a matter of course.
no, it's not saying that, but it is making.
It is a very, I mean, I do agree with the cat on this one, that it's a slightly odd sentence which I puzzled over many times. I mean, it's not a sort of critical part of their reasoning, but it is.
I think it is an important
sentence.
I'm not sure.
Because the reason why it's odd is because in the specific context of this case, it was accepted effectively that, or by the time it got to the Supreme Court, it wasn't a perfectly straightforward issue of causation because the claim had failed. I mean, sorry, the allegation had failed because it was all frightfully complicated to work out whether Sainsbury's was passing on particular costs or whatever.
Well, the factual causation analysis, yes, was complicated, and that was what I referred to earlier, which meant that these issues were being dealt with in terms of matters of principle. But no, in relation to legal causation, the position is straightforward, because what you're asking yourself as a matter of legal causation is this the type of relationship which can give rise to passing on if you then show factually that there was the effect in question. That's why I took you to the British Westinghouse case, which illustrates that where you're dealing with something that arises by reference to an external contract like a contract of insurance, of course, you don't say that legal causation will be made out. That's not the proximate cause. Here, as a matter of...
Well, the British Westinghouse case is setting out the test for legal causation.
Yes, it is.
That's in that passage that they've quoted immediately above the bit we've been looking at.
Yes.
If the action arises out of the transaction,
Yes.
then
Legal causation as well.
other things being equal, if the facts establish causation, then there will be mitigation, or the claimant will have to give credit for whatever the saving is, or the profit is, or whatever.
Yeah.
But on the other hand, if it's a wholly independent transaction, then you don't even get to.
Of course, that's right. I mean, whether you call it legal causation or proximity or remoteness, these are...
Well, I think that's right, isn't it? Because in
those
other
are
cases it's called proximate
Yes,
causation.
exactly. It's proximate causation, because what you're doing is you're saying, of what type of relationship are we talking? Is this the type of relationship that can give rise to a pass-on claim, before we then carry out some detailed analysis about whether or not the factual causation is met? And we say the tribunal, we say actually this is pretty straightforward. I'll come on to the MIF umbrella judgment in a second. And this is something that the tribunal just got wrong. It misdirected itself in relation to these issues and got confused. In fact, it might be just worth moving on to the MIF umbrella judgment. It's in the same bundle, authorities 4 at tab 26, starting at 1487. And here we've got the cat grappling with the multiplicity of MIF cases that are now around, and particularly dealing with issues concerning passing on. And I'm not going to go through all of it, but you see the issue that they're grappling with at paragraph 7, where they explain that what they want to do is articulate the law in relation to passing on, so as to clarify it for all of these cases. And these cases involve both direct purchasers and indirect purchasers. And it's for that reason that one gets over the page at 1492, paragraph 12, a heading, the perils of bilateral dispute resolution, which is highlighting, and perhaps it's just worth the court reading paragraph 12, which is highlighting the complications that can arise in relation to these sorts of claims. And if one goes on, I'm not going to, obviously it discusses this bilateral dispute resolution problem in more detail, but if we move on to paragraph 16, at 1494, page 1494, for these reasons, notwithstanding our simplifying assumptions, we consider it's necessary to regard the claims against A, the defendant, in the round, and to articulate the law so that, to the extent practically possible, consistency of outcomes achieved in the broadest sense. That means that the objective is to ensure that A neither pays too little nor too much, on the assumption that all possible claimants bring a claim against A. Now, that is a simplifying assumption, but they're trying to work out how the law should operate against that theoretical position. And then they identify 3 difficulties: evidential, definitional, and legal. I will pick up, if I may, just over the page at 1500, so paragraphs 25 and 26, and it's a point we're going to come back to, the importance or otherwise of identifying the class of persons to whom any overcharge might be passed on, whether or not that's an important factor, which was canvassed by the tribunal in Sainsbury's, as quoted in paragraph 25, where you'll recall that the tribunal in Sainsbury's said that in order to make out pass on, you needed to show where it was going effectively. And then at 26, it's pointed out by reliance on the Court of Appeal that can't be right. And that is an important consideration. Now,
Be evidentially relevant, and then
yeah, we're not saying it's not evidentially relevant. As I'll come on to say,
it's not. I mean, the point they're making there, the point was being made in the Court of Appeal was that it wasn't a knockout point of law.
absolutely,
You haven't identified a class.
yeah,
But the fact that you haven't identified a class might be
it might be material.
highly germane to whether or not you actually show a failure to litigate or
Yeah, we'll come on to how
mitigation or
germane.
whatever.
But yes, I'm not, sorry, to be clear, I'm not ruling it out, but I think it's
No,
important to just set out that position. Then paragraph 28, you've got the definitional difficulty. I'm not going to dwell on that. That's an interesting discussion essentially about categories 2 and 3 from the Supreme Court taxonomy. Then you've got the legal difficulty at 4, where it's grappling with this issue about pass on being an interesting legal phenomenon in that it acts both as a defence and as the basis of a cause of action, depending on whether you're the direct or indirect claimant. And it discusses that through to paragraph 40, and then in 41 through to 45 goes through some of the case law on mitigation and makes a number of the points I've already made, referring to Westinghouse and Supreme Court in Sainsbury's and so on. So I won't go back through that. Then if we could pick up further at 49 on page 1509, the legal difficulty. Because at 48, you can see at the top of this page, we will proceed to explain why we consider there is no legal issue to arise in section D below. So, strangely, although your lordship may have pored over the one sentence that we were referring to, the tribunal in dealing with this finds that there isn't a legal issue. And that's what they deal with in paragraph 49 onwards, quoting the Supreme Court, and you'll see that proposition B is the sentence we were just referring to in that. I don't know if you see that in the quote. The cat has just interposed references, so it's proposition B. And then if we go over the page to page 50 and go down to 50 little 2, little brackets Roman 2, proposition B, this is a reference to the fact that causation, which as we've said, the second aspect of mitigation turns on, itself has two aspects, legal causation and factual causation. Factual is more obvious, consideration of the effect. Legal causation concerns the question of whether, even if the effect of the alleged mitigating conduct was as a matter of fact to reduce, as a matter of legal policy, it should serve to reduce or eliminate damages. So this is why I refer to it also as remote or proximate causation. And it goes on to discuss that further. And if we go over the page, it refers to the Supreme Court having referred to the two aspects of causation and then saying, it seems to us very difficult to identify any policy reason why B should nevertheless continue to be able to claim the overcharge from A despite having passed it on to C. Indeed, one can see very strong reasons for not permitting D to persist in such a claim. Because as we've described, on these facts, C will have a claim against A and A shouldn't be obliged to pay twice over. Frankly, we can see exactly why the Supreme Court regarded this as a no-brainer. As the Supreme Court noted, the difficult question is that of factual causation. So we say, when you're talking about category 4, generally it will be a case where it is going to be a no-brainer. If we go over the page, to paragraph 51, we consider there's no point of law that we need to resolve. Although the Supreme Court was referring to retail businesses, we consider exactly the same to be true of other types of business, for example, councils, local authorities and universities that feature in the proceedings before us. In other words, where you're dealing with category 4, it's very difficult to understand how there is any sort of problem with legal causation. The final case I was going to take you briefly to was Stellantis, which is in the next tab. Again, obviously, two members of this composition very much familiar with it. I won't deal with it in any detail given the level of familiarity, but what was being dealt with in this case was an appeal in relation to a category 3 pass-on claim.
Just going back to paragraph, which paragraph it is now?
50 or 51 perhaps?
Paragraph 52.
I'm sorry.
Paragraph 50, subparagraph 2.
Yes, of course.
That citation from paragraph 215, the straightforward citation.
Yes.
So the cat in this case is reading that as effectively a restatement of the British Westinghouse principle.
Yeah.
Which isn't actually what it says.
No. Well, it's not so much saying it's a restatement.
What it meant.
It's what it's doing is saying that where you're talking essentially about inputs coming down a value chain, to use the jargon, it is very difficult to see on what basis, when you're talking about proximity, remoteness, or legal causation, you can possibly say that applying the Westinghouse principle, you don't have legal causation there. That's what it's saying. So it's not restating the principle, it's just saying this is a clear and obvious instantiation of the Westinghouse principle. And that's what the cat is finding here. I was just going to go to the Stellantis case, which is obviously rather different because
It's a category 3 case.
it's a category 3 case and it's a pleading case. So what was being asked here was, can you run a theoretical pleading with effectively no evidence but some economic theory in order to be able to maintain a category 3 pass-on case? And this was, obviously this court dealing with these matters, this issue had been raised previously in these proceedings earlier on, and it had been rejected by the tribunal that a category 3 pass-on case was not permissible on the basis of merely theoretical pleading. Stellantis maintained the position and decided it would test the issue before your lordships, and your lordship said no, essentially following very closely what was said in the previous tribunal rulings, that mere theoretical analysis is not sufficient. And in doing so, your lordships referred to a number of indicia that might be relevant for the assessment of whether or not you could maintain the pleading. And we can see this essentially picked up at paragraph 22 on page 1527.
Yeah.
This brings me to a second question, which is the evidential standard that the cat or court must apply to determine whether a pleading is to be allowed to proceed to trial. And then at 24, relevant policy considerations. And these include the fact that pleadings should, the requirement for evidence to support pleadings shouldn't be too high. But then at 26, all these considerations have a common core. Whilst the rights of defence must be observed, nonetheless, where a claimant has a justiciable right, the procedural and evidential rules governing the enforcement of that right, must not be allowed to become so onerous that they undermine or weaken the very right itself. And there's reference to the effectiveness principle.
Yeah.
Then over the page at 31, we've got consideration of the Royal Mail case to which I've referred you. And then if we skip forward, if we may, at 1538, under the heading lack of realism of the pleadings, which probably betrays where the conclusion is going to come, you have a discussion of what was actually found in the pleadings. And then over again, 1540, evidence indicating a realistic defence of mitigation by offsetting.
Sorry, I lost you. Where
I'm
is
so
it?
sorry, it's paragraph 70 at 1540.
Yes, I see.
I was skipping through the details of the pleadings. And what's cited there in 70 is material from the tribunal's judgment in Royal Mail of the sort of indicia that might be material to supporting whether or not a pleading can be maintained in relation to pass on category 3. And that includes knowledge, nature and amount of overcharge, proportion of relevant expenditure, relative ease with which the claimant's business could be expected to reduce a certain input cost, or the fact of other supplies being made by the defendants having been renegotiated. So it's the sort of things that you might expect in a pleading if you were going to support these matters. And then there's consideration of those indicia from paragraph 74 onwards on page 1542.
Yeah.
The observation in relation to knowledge at 75 is obviously apposite. If you knew about an infringement, you probably just wouldn't accede to it. You might do something about it. Therefore, knowledge in and of itself is not particularly important. Secondly,
I mean, just to be clear in terms of knowledge, I mean, you could have knowledge of two things. You can have knowledge of the fact you are being charged a certain amount, or you
Yes.
can have knowledge of the fact that it's being arrived at in an offensive way.
yes,
Plainly, knowledge of the first matters, but in all these cases, you would expect to have knowledge of the first.
yes, exactly. And essentially what's being said, I think the observation being made by my Lord Lawyer's screen in 75 is in relation particularly to the second, that if you had knowledge that it was an infringement that was giving rise to these things, pass on will be perhaps lower down your list of concerns at that point. I think might be put loosely. Then 76 is the small proportion. 77 referred to the ease with which the business could be expected to reduce certain input costs or input costs generally. So it's probably sensible to think of category 3 pass on. It's very different from the sort of coming down through the value chain, which I was describing for the purpose of legal causation. You've got something very different going on with category 3, which is one of your costs goes up and therefore you try and push completely other costs down. And as soon as you start thinking of that in British Westinghouse terms, you can see why you're going to need quite a compelling story to make out legal causation, because the other supplier costs that you're talking about are, on the face of it, unrelated to the costs that are subject to the overcharge. And so unless you've got some story, some evidence to put together that interrelationship story, then it's easy to see why a pleaded case merely on theory doesn't get you sufficiently far with these things. And then fourth point is in relation to renegotiations. So they're all dealt with there perfectly understandably as indicia that go to whether or not the pleading is sufficient. And then the one other point to pick up here is a submission that was advanced. Pick it up at 81, 1543. What was being pleaded was that the defendant would be in a catch-22 predicament where the tribunal accepted that in principle a defence could be pleaded, but simultaneously made it impossible to plead sufficient facts. And as it's put crisply, the short answer to that is if the defendant doesn't have any realistic evidence of a possible defence, then it has no basis for going fishing. I just take you through those because those are the cases which up to now have dealt with these passing on issues or the core cases. I'll now move on. The way I'm going to deal with it, I'll just make one or two very brief remarks about regulatory context, then I'm going to take the tribunal through some of the key parts of Mr. Ridyard's judgment, because they explain how you should do this effectively, and then explain by reference to that why the majority have got things wrong. So just one or two quick remarks on the regulatory context. Your Lordships will appreciate that both of the respondents were subject to very significant levels of price regulation during the relevant period. So there were regulatory price controls in place for much of the infringement period in relation to large amounts of the supplies which they made. Not all of it, I should stress, but significant amounts. And the question is essentially, in the pass-on context where you have that sort of regulatory control, whether there would have been a different outcome in relation to the regulator's price control in the counterfactual, because both of the claimants priced up to their regulatory price caps, as would be expected in relation to any regulatory scheme. So that's the critical question which we're dealing with. And just in very broad terms, there were a number of periods with slightly different controls in it. I will focus on the one or two of the periods where the most significant claims of overcharge are made, because that's obviously the central point here. For instance, in relation to Royal Mail, there was a price control 2 period. Just to give a broader sense of it, during that period, the allegation is that around 26% of all of the overcharge that Royal Mail suffered was incurred during that one period. And that, during that period, the regulatory scheme was what's known as RPI minus X, which you may well be familiar with. But broadly speaking, what you're doing there as a regulator is you're taking the costs and asset base of a company and allowing it to make a return above those costs and asset base at a certain level. Now, it can be at RPI. You insert some kind of reduction in RPI to incentivize efficiency, or you put a different profile of reduction over time, which is sometimes called a glide path in relation to the returns that the company's allowed to make, or rather the prices that it's allowed to charge by reference to this. The key point is that the price control depends on what costs you're feeding in at the start of it. So that's true PC2 and indeed PC3 for Royal Mail. Things are slightly more complicated in relation to BT because they had multitudes of glide path controls, and I'll come back to that and how the experts dealt with that in due course. But in relation to all of them, the key point is that although these glide path controls didn't apply across the board, they applied for very significant periods in relation to the periods where there were the largest overcharges, and they did depend on what costs were incurred by the companies. Or more exactly, what costs the companies expected they were going to occur across the period, and then they were incentivized to structure their business to try and reduce those costs and act more efficiently. So with that, if I may, I'm going to go to Mr. Ridyard's judgment on the issues to do with supply pass-on, which is tab 17 in the core bundle. Starting at page 393, I think. Yes. Now, Mr. Ridyard's judgment has two parts. One is the analysis of supply pass-on and the impact on price controls, and the second is whether or not
actually there should be any reduction. And I'll deal with it in two parts. I'm going to explain why he's right on his first part of analysis, and the second part, the coda to his dissenting opinion, strays into non-legal policy issues, which I'll deal with at the end of my submissions. But we see 393, the dissenting opinion. I believe, contrary to the majority, that it's likely that both claimants did pass on a substantial amount of the overcharge to their downstream customers, and that there's a sufficiently close causal connection between the overcharge and a likely pass on. However, I'm not persuaded that the SPO argument should be used to impose a reduction. That's the coda point that I've referred to. And then at 694 over the page, he explains the structure of how he's going to approach matters. He sets out at 395 what he understands the legal test for pass-on mitigation to be, and he summarises a number of the points that I've already taken the court to. And then at 696, under heading little b, he talks about the pass-on mechanism in this instance. He highlights the fact that a number of pass-on mechanisms have been canvassed, and he refers to the Supreme Court in Sainsbury's and the various options. And he emphasises that option 4 is to do with the claimant increasing the price of the product that use the input affected by the overcharge, and that this, as he puts it in 697, this case squarely falls within option 4. In other words, that Royal Mail and BT both used trucks as an input into their provision of their respective postal and telecommunications services, and that they were able to use the regulatory process, and to a lesser extent normal forces of competition, to pass on higher truck prices in elevated prices that they charge for these services. I regard this as a very important feature of this case. And he distinguishes option 2 or 3 from option 4, and why it's critical to the understanding overall. He then explains some of what he considers to be the economics of pass-on, which are extremely helpful, clear and interesting. I won't read through all of that, but you'll see at 699, the main results derived from the economics of pass-on do not envisage options that would fall in options 2 and 3 of the above categorisation. In other words, it's not normally predicted that profit-seeking firm will respond to an increase in the input cost of making product A by reducing the amount it seeks to pay for inputs to unrelated products B or C. So this goes back to the points we were making, canvassing earlier. And he says, not to say option 2 or 3 can never be predicted outcome, but it does indicate that a claim of mitigation that relies on such mechanism is likely to find itself battling against established economics. That is in contrast to point 4. He highlights the Stellantis judgment in the CAT in that regard, and the Court of Appeal's approval of it at 701. Then, once we get to 702, he looks at those various indicia that I was referring to in the context of Stellantis, which he outlines over the page: knowledge, relative size and relationship, and identifiable claims by identifiable purchasers. And in knowledge, essentially he picks up the points that the court already has. You see this at 704. Whilst I agree that the visibility of an overcharge would make it more straightforward to establish a causal link with any consequent change in claimant behaviour, it can't be regarded as a necessary condition, and I don't place any weight on it, place significant weight on this factor in my assessment. Then relatively small size, the second factor. In the current case, this is at 705, there's no dispute that the overcharge we found, while substantial in its own right, is extremely small relative to the value of the claimant's downstream businesses. This factor renders any attempt to measure pass-on empirically hopeless, and it's plainly present, and it plainly presents the biggest obstacle to proving the existence of pass-on. The key question is whether that practical impossibility of measuring the specific downstream impact of pass-on effect is sufficient to prove, on a balance of probabilities test, that such an effect doesn't exist. I believe this is the factor that has most influenced my colleagues to reach their conclusion on pass-on, and I fully understand and respect their rationale. However, I do not agree that the fact that an effect is too small to be measured or separately identified within the price of the downstream products means it must be unlikely to exist. To make that assessment, it is necessary to look to other contextual evidence that might reveal the existence of a likely pass-on mechanism at work. And then he talks about the relationship between upstream and downstream costs, which is essentially falling in within the option 4, category 4. And he refers to various discussions about this issue where scepticism was expressed about this relationship in previous CMCs. But as he points out, those discussions, A, seem to actually mistake what was option 3 and what was option 4, and B, as it's pointed out at 709, makes predictions about what economists think that perhaps economists don't think. If we go to 710, if I've laboured this point, it's because of the critical importance of understanding the relationship between truck costs and the claimant's downstream services. One might, in common parlance, say that trucks and postal services are unrelated, but to do so would not be a true reflection of the economic substance. Trucks are purchased by the claimants in order to enable them to provide the downstream postal and telecommunications system services, so they're in both cases components or costs directly used. And then if we go to 711, the factual evidence on this can be found in the evidence presented by DAF's pass-on expert, Mr. Besant. Truck costs formed a part of vehicle costs for both claimants. The detailed information on vehicle costs was included at a very granular level, albeit as one small part of a much broader cost picture in the cost data that was collated and submitted by the claimants to their respective regulators. Since truck costs were included in these cost figures, then it seems clear to me that the overcharge must have been included in them during the relevant time period, whereas in the counterfactual, it would have to be deducted. In other words, when you went to the regulator and said, here's my predicted cost for the next X years, one of the cost heads you had was vehicle costs, because that was a component. One of the key vehicle costs was truck costs. Those would have been elevated on the basis of the putative overcharge. That was fed into the regulatory scheme, is what he's saying. And if we go over the page, 712, the next question is to address the causal connection between the overcharge and downstream prices. As Mr. Besant's evidence makes clear, that must be addressed primarily by examining the way the claimant's businesses were regulated. Both claimants operate natural monopoly networks which possess latent market power. Whereas firms that compete in competitive markets are generally free to set their own prices, the claimant's monopoly networks are required in effect to obtain permission to raise prices, which is granted only after a process of regulatory scrutiny that culminates in the provision of a price cap or similar constraint. And then he describes how that is supposed to be mirroring competitive markets, but it's obviously a specific process. And the last sentence, Mr. Besant's evidence detailed how the respective regulators expressly established pricing mechanisms and pricing controls by reference to the costs and the purpose of achieving cost recovery. And then he says, he recognises in 713, if economic regulation took it the most naive form of a rule that simply allowed claimants to recover their costs, the causal link between overcharge and downstream regulated prices would be clear. If truck costs are part of the total costs of operating postal or telecommunications service, the regulator would set price controls to allow claimants to recover their truck costs, and by definition it follows, it would have also allowed them to pass through the overcharge. As a hidden component, I see no reason why the fact that the overcharge was small in relation to total costs or revenues would in any way alter that conclusion. So that's the...
Does it inevitably follow? Does it not depend upon the details, the minute details of the RPI minus X formula, and the extent to which there was leeway for a company to flex its costs? There could be all sorts of headroom. You might be squeezed at RPI minus X. There might be headroom.
Yeah.
Does it necessarily follow?
No,
Inevitably follow?
Well, in the model that he's positing, it's analytical, because he's saying if the control was you get your costs back, it's cost recovery.
So he's got two ifs in there.
Yeah, he's illustrating the basic principle, which is the regulatory scheme is intended to allow cost recovery, but with an incentive structure. He in 713 is saying if you just have a cost recovery model, then it is clear that even if it's a very small cost, you would pass it on. And the point he's making there is that smallness is not the determinant here. He's then going on to deal with the point, my lord, that you talk about, which is there are more nuances in the regulatory scheme. And what he's essentially saying, and I'm conscious of...
No.
Well, I don't know whether it might be a good moment for transcribers at 3:10 if we're going to run through to 4:30. That was the only thing I was going to say. But what I was going to... I'll carry on for 5 more minutes if that's okay.
Well, I mean, it's up to you.
Yeah. Well, let me deal with the point, because we're naturally moving to the point that my Lord, Lord Justice Green has already anticipated to some extent. That Mr. Ridyard is saying, look, small is not the same as unavailable or not passed on. Because if you had a full costs recovery model, that would analytically be the case. Yeah. That is the goal of the regulatory scheme, albeit with incentive structures and more nuanced and complicated structures. He accepts that. In reality, this is 714, there are a number of attributes to the regulatory systems that apply to the claimant's businesses that depart from this naive cost-plus model. I don't propose in this opinion to deal with all of these complications or to run through the specific pass-on mechanisms that arose for each of Royal Mail and BT in each of their separate business units or phases of regulation.
If you move away from the naive model,
yes,
because we're not in that territory.
Yes,
because what we're in with RPI minus X is effectively a price control mechanism.
Yes,
that says, well, okay, your costs are £100.
Yes.
But for a variety of reasons, regulatory reasons, and to make sure that you make some savings and run your business efficiently, yes, we're only going to allow you £90.
Yes. And
isn't the point that's being made by the majority is that where that happens, if what has happened is that in the previous year it was 95,
yes,
and you only got 90,
yes,
it's impossible to say that the figure you got has, as it were, been dictated by the overcharge, because the overcharge might in fact have been disallowed in the reduction.
Well, I don't think one, even taking the model that you're positing, my lord, you wouldn't say the overcharge is not allowed. What you'd say is your overall costs aren't allowed and some component of the overcharge.
By definition, how can you say that? Because the overcharge has increased your overall costs, yes, but you're not going to recover your overall costs, you're only going to recover 90% or whatever, yes, it is. How can you say that the overcharge has been passed on?
Well, there are two things here. First of all, what Mr. Ridyard does is he looks at the evidence that there is about the regulated scheme. And what he says is that given the way that the regulated scheme was set up, if you had this small change in your input costs, there's no reason to think that wouldn't have fed through because of the mechanistic way that the regulatory scheme operated. What the majority asked itself was, once you've got this price at the end, does a tiny change make any difference? And the point Mr. Ridyard's making is, no, that's the wrong way of looking at it. You need to look at it when it's inputted. Now, your point, my lord, is I think that if you input, yes, I'm sorry, I don't want to presume.
Don't, I could be wrong.
Yeah. I understand your point to be, in the real world, costs component for vehicles, including trucks, was 105. In the counterfactual world, it would have been 100. The point your lordship is making is, but if there are various bits within that regulatory control which mean that the Ofcom play with what it is of that cost stack you're allowed,
Yeah.
then in those circumstances you can't be sure that the overcharge would have been passed through. And I think what you're saying is, well, let's assume that your costs were 105 for vehicles, and actually you were only allowed 100 for vehicles. That means that the overcharge isn't passed through. But the point that Mr. Ridyard makes is that if Ofcom was moving everything down by 5%, then if you'd put a lower amount in at the start, Ofcom would have moved that down by 5%, because it's not thinking about whether or not this is an unlawful charge, it's just thinking about incentive structures. And so the fundamental point that Mr. Ridyard is saying is, look, if this is the way your regulatory scheme works, you will feed it through. It's not the 100% pass-through that the naive total cost recovery mechanism provides, but it is some substantial part of that that gets passed on. And what the majority have done wrongly is thought, oh, well, it's very small, it's only 5. When I compare that to the total cost, the total settlement, what I'm allowed to charge, which may be millions or billions, that just comes out in the wash. And therefore they ask what Mr. Ridyard refers to as the what changes question in relation to the outturn. They don't ask what was different in the regulatory scheme, and that's why the regulatory scheme is so important here, and that's why Mr. Ridyard is right in his approach, and he's right that it is obviously a matter of both legal causation being made out and factual causation made out, and as I'll come on to perhaps after a 5-minute break, what I want to explain is how, because the majority ended up confusing both legal and factual causation and getting this question wrong, they misdirected themselves in relation to this.
Let's take a break then.
All right. You know the live stream's still on. Is that supposed to be? Yeah, I got it. We've not said anything rude or inappropriate, except about yours use of the phone.
It's only going on in the Supreme Court.
When James is elevated to the Court of Appeal.
Good. I'm just going to stay here. You go to one back.
I want to see the drinks.
Guys. So I was both taking you through Mr. Rijard's dissent and also anticipating where I'm going with this in relation to the majority. But could I go back to Mr. Rijard's judgment? Paragraph 714, 403. I started referring to this in response to a question from my Lord Justice Green about the reality. And what Mr. Rijard does is he talks specifically about the complicating factors, and indeed one of them is one of the factors, my Lord, that you raised. So I'd highlight three areas in particular. Evidence of the steps taken by the regulators to disallow part of the estimated costs and budgets that were presented by the claimants, recognising the danger that the application of simple cost plus formula would encourage and reward excessive and inefficient levels of cost. This is exemplified by two episodes cited above in the PC3 period where Royal Mail bid in for very high vehicle costs and was cut down, and 2009, 2010, where BT's bid for fleet costs were cut back. So that's precisely, I think, the situation that you're talking about. And if you just go down to 715, as the first of these, I acknowledge the pushback from the regulator does create a risk that regulated firm would fail to gain full revenue compensation for some of its projected costs. And it must be possible that if such pushback arose in relation to truck costs, it would have also applied to any overcharge. But whilst that's potentially relevant for evaluating the rate of pass-on, it does not, in my view, undermine the likelihood that the reasonably incurred truck costs were more likely than not to be remunerated by the regulatory process.
It does be clear that the stress there is on rate, is it? Whilst that is potentially relevant for evaluating the rate of pass.
Yes. Yeah, so he's saying there is definitely pass on, but as he goes on to fairly say at paragraph 721, he's not saying it's 100% pass on. And I think everyone concerned with this recognises that. But the point is that if you think about the counterfactual world, if the regulator is putting pressure on costs for efficiency reasons, it's doing that completely aside from the fact of the existence of the infringement. And therefore what Mr. Rijard's saying is that in the counterfactual world they might have pushed down on costs, but they would have pushed down on costs generally, and that doesn't tell you that the costs weren't being passed through in those circumstances. That's the issue which he's identifying. And then he goes on in little 2 into 714 to deal with a different issue where Postcom as it was at that time, disagreed with projected sales volumes, which led to a large gap between the two sides' views on the level of revenue required to finance the business. Because one of the things that's being considered in the regulatory scheme is that you're able to price to actually finance. That's why you're looking at your costs as much as anything else. And in the event, to actual Royal Mail revenues that were some 3 billion below the regulator's estimates, and hence a price control outcome that failed to remunerate Royal Mail's projected costs. So they tried to set a price control and it had effectively gone wrong. But as you see at 716, as the second, and accepting both that in this instance Postcom made an error of judgment in underestimating volume losses, and that this error led to a price cap that failed to cover Royal Mail's efficient costs. In my view, the most reasonable inference is to assume that this error would have occurred with or without the trucks overcharge. In other words, the fact that something goes wrong in the regulatory scheme in outturn doesn't tell you what you'd have been allowed at the input stage. And it's what you're allowed at the input stage that dictates in this regulatory regime whether or not there's pass on. And then the third issue he deals with is at 714(3), evidence that parts of both of the claimant's businesses, for instance Royal Mail's parcel force, are not natural monopolies and operate under competitive conditions. And he there at 717 recognises that they weren't subject to regulation, so it's different. So there is a different causal influence. But whilst it's true that firms, this is at 717, operating in competitive markets have no assurance they'll earn revenues to compensate their costs. Costs often are a strong driver, and so some degree of pass-on remains more likely than not. But what he then goes on to deal with at 718 and 719 is that even if there is a different approach in relation to the non-regulated elements, that doesn't negate the pass-on across the piece in relation to Royal Mail and BT, because in relation to the regulatory scheme, the position is, as I've explained, in the counterfactual world, because of the mechanisms that would have applied, you would have got pass on, or as he puts it, would very likely have got pass on. And it's worth then just turning on to page 407, because paragraphs 722 through to 724 particularly address what I was just referring to before the short break, which is the difference between the majority and Mr. Ridyard's approach. Because the majority essentially followed Mr. Harvey in this regard. And you'll see at 723, he based his assessment of the counterfactual on the question of whether, starting from observed outcomes, there was evidence that the claimant's prices were fine-tuned to costs in such a way as to generate a different outcome. Mr. Besant criticised this approach on the grounds it considered whether a change in costs equal to the overcharge would affect outcomes that were actually observed. He emphasised there is no change involved in the counterfactual assessment, but instead the comparison should be between two separate scenarios, actual and counterfactual, in which the claimant's input costs happen to differ. And that's the essential difference here. And what Mr. Ridyard then refers to is that they're making the what changes fallacy in relation to outputs, and that's at 724. And although this is attributed to Mr. Harvey, I consider Mr. Harvey's what changes question is the wrong one to ask when addressing the legal question, and that this biases the assessment in a way that's likely to understate the degree of pass on. That is in fact what the majority did. I should say at 725, and I won't go through this in detail, deals with the position in relation to BT, where you have the multiple glide paths. And the question there is, if you had multiple glide path controls, is it probable that one or other of them would have changed such that if there hadn't been an overcharge, you would have been permitted to recover less overall? And Mr. Ridyard says, yes, the fact that you've got multiple controls and only one of them might tip at a point and that changes things, overall doesn't undermine the overall likelihood of the pass-on effect. And that's what he deals with there. through to 727. So we say that was the right approach, straightforward on legal causation, no issue to see there, move straight along because you're dealing with this option 4 input costs issue. And then when you have to look at the actual factual evidence, you don't do this what changes in relation to return, you look at the counterfactual in relation to inputs. If you look at the counterfactual in relation to inputs, it is very much more likely than not that there would be some, not 100%, but some significant overcharge pass through. So with that, I will turn then to the majority's position. And if I may, I'll start at paragraph 550, which is on page 355. So paragraph 553.55, what you'll see there is we get the recitation of those indicia, again, at 550. And then we see at 551 an emphasis on there not being knowledge of the existence of an overcharge. 552 accepted the overcharge was small relative to overall costs and revenue. And the claimant's main point being that their prices weren't fine-tuned enough to be able to conclude that they were actually higher as a result of the overcharge. 553, the relationship or association between the trucks bought or leased by the claimants and the products sold by them. Where there's a comparison, sorry, complements, just so that you understand, is complements is the argument that when you buy a truck and a trailer if you're buying a tractor unit. If the prices of the tractor unit, the pulling bit went up, if you're buying the whole unit, then actually the trailer price as a matter of economics would probably go down, and that would be a form of pass on. And it was said to be conceptually viable, but on the facts wasn't made out. And resale pass on is if you pay more for trucks new, then that will inflate the used truck market. Again, conceptually works. In practice, it was found on the facts not to be made out. 554, the question of identifiable claims by identifiable purchasers is an important, albeit not necessary, factor. The factual question which we're concerned is, as defined by the Supreme Court in Sainsbury's, where the passing on was transferred all or part, passing on the cost to their customers, the claimants transferred all or part of their loss, it might be thought that the others should be identified, whether as a class or not, together with at least an approximation as to the amount of the loss that was so transferred. Now, to be fair to the tribunal, they're not saying it's absolute, but it is rearing its ugly head again as a concept here, which frankly, for the reasons that were articulated by the Court of Appeal, it is not a significant matter. And then 555 discusses the experts. Then there's a discussion of does size matter, and references to Mr. Ward's metaphors of needles in haystacks and grains of sand. But I'll pick it up, if I may, at paragraph 567, page 360. And the reason I just pick up 567 is the question that's posed at the end. The question is whether margins are maintained by automatically raising prices by the amount of a costs increase, however small that increase may be. And with respect, that's not the right question. That's a question that's actually much more complicated. The question is much simpler here, and the one that Mr. Ridyard was, even if one can read that question so that it can be translated into the right legal test, that's not the way to put it. Because what it ends up doing is moving you towards the what changes fallacy, as Mr. Ridyard put it. Then we've got the expert evidence being discussed, and what I need to pick up is from 571 onwards. The position that is adopted by the tribunal, as it describes it's more relevant to consider where the expert actually takes us in the case in relation to SPO, given our conclusions on the law. And this, I have to say, is something of a difficult passage within the judgment. 572, as we've already said, in relation to the 4 factors, none of them are present in this case. And so they refer to knowledge, size, direct association.
And for what it's worth, I do find it hard to see how knowledge in this sense is of any significance. I mean, if your Royal Mail is relevant to you to know how much you are being charged, but it doesn't seem relevant to know that it's an overcharge.
Well, it isn't. And so there is a real confusion here. There's also a confusion referring to the identifiable purchasers once again here, because it's a complete distraction from what you needed to be focusing on as the proper question. But the problem becomes greater in 573. In the circumstances, so this is having regard to these indicia, in the circumstances, we do not think DAF can satisfy the legal test for causation, which requires the overcharge to be a direct and proximate cause of the increase in specific prices. Even if as a matter of forensic accountancy, DAF's able to show the minuscule overcharge can be traced through a series of internal steps, judgments and regulatory intervention resulting in a higher price setting, the absence of the 4 factors means that the overcharge is too remote from the downstream prices. Now this is a finding that there's no legal causation here. This is just wrong. I took you through the case law in relation to it. It doesn't make sense. While the 4 factors are not themselves decisive or necessary, we think that in a situation where none are present, the evidence of factual causation needs to be that much stronger so that the requisite proximity can be established. I mean, it's very confused here as to what's going on. It's wrong in saying there's no legal causation, because plainly there is, and the MIF umbrella judgment rightly said that's a no-brainer here. But then it's wrong again in the last sentence, because it's saying you need more compelling evidence when these 4 factors aren't there. And that, of course, colours the way in which the majority then consider the remainder of the evidence. Because they're saying we need to hit a higher standard, even though we're taking into account a range of factors that are marginal indicia that were relevant when we were talking about pleadings in Stellantis. But when we're asking our question whether or not the overcharge is passed on, really aren't informative. They make a clear legal mistake, and then they colour the way they approach the evidence.
Could we just read that last sentence again? So when if the 4 factors don't apply, then you've got no easy analysis which tells you what the answer was. So are they saying any more than, if we can't get guidance from those 4 factors, then we need something more? Now the word much stronger may be, I mean, it's just their need is stronger. It doesn't necessarily mean the evidence is strong. I'm not certain they're saying you need to have very, very strong evidence or just some evidence. It may be just clumsily expressed.
Well,
but the need
it's
needs to be that much stronger.
With respect, that's a remarkably charitable reading of the evidence of factual need causation needs to be that much stronger. It's the evidence that needs to be stronger. But look, it's a legal error, and then it's a confusion. And then it says, but 574, we'll still examine the evidence and the expert's opinion to see if it's strong enough to overcome the absence of the relevant factors we've identified. Despite Mr. Bazant's careful, meticulous professional approach, the material he had, we're clear that his evidence doesn't sufficiently bridge the gap between the overcharge and the downstream prices so as to establish the facts, the requisite proximity to satisfy the legal test for causation. So again, it circles back to a mistake. So it's mixed up legal causation. It then appears to be saying you need stronger evidence. That's plainly wrong as a matter of law as well. He then says, but we're going to go on and look at the evidence in any event. But what it does is it applies the what changes fallacy throughout. What we see as we work through is essentially the tribunal fishing for ways to say, no, too small, doesn't matter, throughout, in circumstances where they're not properly analysing the evidence as they should do, and as Mr. Ridyard has done. You see their consideration of the facts starting at 575 on 362, page 362. And just given time, but also the importance of PC2 and PC3, I'll go to PC2, the consideration of PC2, which is at page 366. And the 596 is a description of PC2, 597. And then what you see at 599 is that they say that the price control was over a very big number, 17.8 billion, whereas the estimated overcharge attributable to this period was in the region of 8 million. On any view, that's a tiny amount, but Mr. Besant concluded that Postcom's decision on the level of the price cap, whether by a change to P0 or X, P0 is the alternative percentage to RPI, would have been likely to be different in the counterfactual without the overcharge. He came to that conclusion for two reasons. One, because Ofcom would want to maintain the headroom figure of 21 million, and two, because of the underlying relationship between Royal Mail's trucks and prices. Mr. Harvey put forward the sort of general approach that this is very small and wouldn't be taken into account. But again, this is doing the what changes analysis, not looking at an input into the process that was smaller. And there's then a discussion of some of the P0 percentages. And Mr. Besant, and this is at 602, accepted that this shows that there is an exercise of regulatory judgment at the end of the process, but he maintained that a different set of costs at the outset would have led to a different percentage. We think that his analysis fails adequately to account for the overarching regulatory judgment that ultimately determines the price cap. And then he deals with a headroom issue, where he says that where it's suggested that the headroom of 21 million would mean that an overcharge of 8 million wouldn't be problematic. The headroom would be changed.
I think it's 4 million, isn't it?
It would be. I'm sorry, I'm reading the last sentence of 603, but you're right.
599, he says it's half the 8 million.
It would be. At 603, they actually talk about the 8 million. So they're making the point in relation to either.
Yeah.
And 605 agree that there's no specific headroom figure. And we do not think that Mr. Besant has demonstrated it's highly likely, or at least more likely than not, that the level at which Postcom set the price controls on PC2 would have been different, but for the overcharge. And as I say, I've directed you to Mr. Ridyard's analysis that says, but if you've got this small change and all else stays equal, which is what you're thinking about as the starting point, you have to ask yourself, would there have been any material modifications to the mechanism that was being used and the outturn that you would have got? And
how much do we know about the mechanism that was being used?
well, we don't know, we didn't have internal evidence from Postcom or Ofcom, but we did have a vast amount of material because, of course, Royal Mail and BT had to submit cost materials and make submissions to the regulators in relation to all of these price controls, and particularly in relation to these more recent ones. We had vast amounts of material in relation to it, which was why you could have the detailed expert analysis.
We don't know what happened. We don't know what might have happened had Ofcom known that there was a X percentage overcharge. I mean, if it's secret,
Well, I think that would be that wouldn't be the question one would ask at that point. You'd have to ask what would be the situation if an input cost in relation to one of the cost lines was different. Because I think if they knew it was an overcharge, then it wouldn't be reasonably incurred costs. There'd be different issues.
As we
that
said
arise.
in standard, if they knew it was an overcharge due to cartel, they'd bring it to an end instantly.
Yeah, I think we wouldn't be discussing these things. So
No,
yeah,
that was the point about knowledge in Stellantis.
yeah, exactly.
But
No.
can I just make sure I've understood this? The argument of the majority seems to be, as you put it, they apply a what change analysis. They said it was so small it wouldn't.
Yeah.
If they're right, then it presupposes that customers downstream wouldn't have paid any more or less. They'd have paid the same.
Yeah.
If that's the case as a question of fact, what do you say follows in law from that? Do you mean that there isn't any loss at all, or that there is a loss and it can be covered upstream by these claimants? What follows from the conclusion, if it's correct as a matter of fact?
Well, if
that
there's
there's
zero
been no change?
pass on, then leaving aside questions of the extent to which findings in one court bind courts that deal with these things elsewhere, if claimants' indirect customers came along as a class and
They
said,
couldn't prove any difference.
sorry, they couldn't. No.
You couldn't prove any different.
No. I mean, this goes to something that I'll come on to in relation to Mr. Ridyard.
So is the analysis here of the majority that, in their view, on the facts, there would have been no change simply because of the scale of the operation and the smallness of the size? Is that a finding of fact or law?
Well, the way in which they approach it, as I hope I've explained, is erroneous in law.
They say in 688, they say, we're first of all deciding this as fact, and then we're secondly deciding it as law.
I understand that, but I tried to point out that there were two errors in 573, 574. First was the legal causation error, and that the legal causation error coloured the way in which they approached the facts. And we say that's obviously a legal error. But we do say that there's a third error here, which is the error of approach. The what changes question is asking the wrong question. Mr. Ridyard was asking the right question for analysing
That's
parts.
exactly why I've asked you the question. If you say, why is it, if as a matter of fact, nothing changes, then you accept that downstream there's no loss and therefore indirect consumers have no claim. Ergo, upstream customers do have a claim.
Well,
If it's
obviously
right
that's
as a question of fact.
Yeah,
Because a pass on has to be
Yeah.
a pass on to somebody else, doesn't it? I mean, you may not be able to identify who the somebody else is, but you have to pass it on to the customers.
yeah.
But if the evidence, if on the facts, the majority of the tribunal is right, it hasn't been passed on to the customers.
Yeah.
then
But that's
it
big.
seems to me how they get there.
Well, it does
It may
matter
be
how
right
big.
that the way they got there was as it were incorrect, but the ultimate answer would be correct.
No, well, if in one sense, obviously, I concur. If there was clear evidence that had been properly analysed that said there was no change, then obviously there is no pass on. The issue here is that in making their findings in relation to whether or not nothing changed, the majority made a preliminary error in relation to legal causation, then considered the evidence using the wrong set of glasses because they'd made an error in relation to legal causation, and furthermore were asking themselves the wrong question in relation to the evidence test, which was what Mr. Ridyard was pointing out, as between what changes and what doesn't. So if they had approached it in the right way and found there was no evidential basis, then yes, of course I must agree with you. But we're saying, no, they didn't. That's why it's the point of law. That's why we have this appeal.
So can I just understand the picture? Ofcom or whoever obviously look at anticipated costs.
Yes.
They assess the anticipated revenues of particular scenarios, and then they produce a complicated list of prices that Royal Mail is allowed to charge.
It's not a single overall price that is being charged. They do it by, it depends on the price control, but they can have overall caps, and then they can have what are called baskets, where you're dealing with a collection of products, and that gives the company a degree of flexibility as to how it's pricing. But overall, there is an overall price cap, yes.
So when you take PC2, which you're looking at,
Yes.
you may not remember. I mean, what sort of picture would the regulator have imposed there? I mean, are we talking? Presumably, there's a stamp price.
Yeah,
but
the stamp prices, that's an obvious restriction, yes.
You're not going to change the price by a penny to take account of the overcharge.
No,
So presumably, it wouldn't feed into a change in the overall stamp price. With the second class mail or first class mail, it would be a more complicated adjustment.
well, you can't, the issue here is that you can't make that determination completely. Because if you're at the threshold due to other costs, that means actually you move the stamp price if it goes up a little bit more, or you move it down because it's a little bit less. Actually, it can do, and therefore I can't. You can't deal with it in those terms. That's the danger with thinking about this as small. It can have a tipping effect, which was actually what was analysed in relation to BT. That's why Mr. Ridyard's approach was saying, look at the overall mechanism is so important, because you fall into these mistakes in relation to thinking about how.
So, on the Ridyard approach, the regulator concludes that overall you should be allowed to charge such and such.
Yeah.
In anticipation that you're going to achieve sales, whatever.
Yeah.
Unless you are absolutely on the margin, that's not going to be reflected in the change of the price for a second class stamp, because that
No.
would produce a much larger adjustment.
Yeah, I accept that.
But you say, well, you've got a whole basket of other prices for this, that, or the other parcel, or
Yeah.
whatever, and so on this hypothesis, the change in the anticipated costs could be expected to have some impact
Exactly.
on some price that you're allowed to charge somewhere.
Yeah.
Query who your class of disappointed customers would be if they wanted to sue you.
Well, that's true, and that's a point that the tribunal recognises, because you can't identify specifically where the pass on lands. You can't necessarily identify who that class may be. And we say, okay, but this is a compensatory mechanism. The fact that we can't identify that doesn't mean that there hasn't been pass on. That would be the wrong way around of looking at it, and it's why that indicia and why the emphasis on that indicia by the majority is so problematic, because there essentially is, again, a misconception about what you are sensibly doing here because they're focused on that issue. It can't make a difference, the question of pass on, whether or not there is or is not going to be a potential class claim actually brought. A whole range of issues can give rise to that. Now, of course, when you're ascertaining what the law should be, you do think about, as the tribunal did in the MIF umbrella claim, the possibility of different claims at different levels in the value chain. But that doesn't mean you, in a particular case, you somehow change the way in which you analyse this, because it happens that you can't identify a class, or limitation has lapsed and there's no prospect of a class bringing a claim, for example, which is another potential situation. So the law can't change, notwithstanding that, which is why we have so much difficulty with the identifying the specific class issue. And whilst, of course, the point made by the Court of Appeal was only going to a limited extent to explain these issues when it criticised the CAT for focusing on identification of the class in the Sainsbury's judgment, actually, there is a broader point here.
What does this court do if we conclude that Eric Ridyard's analysis is plausible,
Yes?
and we conclude that the CAT majority's analysis is plausible?
Well,
I mean, these are incredibly complicated value judgments which are made. You might end up with a whole series of alternative plausible techniques.
we accept that we turn up here saying that the majority has not approached this in the right way legally.
Well, that's
and
why
it's-
you have to,
Yeah.
I'm not being offensive, but you have to demonstrate that they've made an error of law.
Well,
And you say, well, that what they've done is that they've formulated the wrong test for the purposes of legal causation, and that's led them into falling into error on factual causation. I mean, that's your case.
yes.
But if you were wrong about that, and that they haven't got the test wrong
Yes.
on as to legal causation, and this part of their judgment is simply looking at factual causation without, as it were, being tainted by some error of law, then it seems to me you must lose.
Well,
Because this court can't substitute. We
no,
may
of
or may
course.
not agree with Mr. Ridyard or the majority. We can't substitute.
No, of course that's true. I just want to nuance the response. Yes, if they've got the law wrong, then that's a mistake.
Of course.
And if they're getting the law wrong affects the way that they approach the evidential test, then that is sufficient for us, and
I
it's
just
wrong.
put that to you. I
Yes.
mean, I accept that.
And as I say, the third point we make is that the test that was articulated by Mr. Ridyard of identifying what would change in the counterfactual rather than what changes, that is the wrong approach to evidential causation as well. So those are all elements. Now, we say they're interrelated because you can actually see where it's gone wrong here. But those are the basis on which we come forward. We're not just saying, oh, there are two plausibles, we're asking you to pick one of them. That wouldn't be sufficient for us. We accept that.
One of the problems with, one of the issues relating to dissents in these cases is sometimes they demonstrate how complicated the evaluative exercise being undertaken by the CAT is. And we've seen this in a number of the cases where we've seen dissents that actually, three people can reasonably disagree.
Yeah.
And it really heightens, from our perspective, we have to keep asking ourselves, what is the role of an appellate court?
No, of course, and we're conscious, and this court has, in a number of judgments recently, indicated that it has a concern about people turning up with fact matters. We understand that.
Yeah.
But
The
what
risk
was
is that we actually find it attractive and seductive.
Yeah, that's the
For
problem.
all
See,
wrong
that's the problem.
reasons.
That's
The
the
risk is
problem.
we get
Mr. Blair.
interested.
You talk us round to such an extent we go and fall into our own error.
this would not be an error. This would be an emancipation, and so we're not troubled with that. And of course, you're right that some dissenting judgments are simply illustrative of the fact that reasonable people can reasonably differ. What we're saying here is that's not one of those occasions. So that's the reason why I took you to it, because that sets out how you deal with legal causation, what the right question is, and how you don't jar against your factual assessment. And that's why we say it's right, not simply because it's dissenting in our favour, but because it is correct. And if I could just very briefly turn to PC3.
Just before you do.
I'm so sorry.
Sorry.
No, of course.
Well, 602, for example,
Yes.
the tribunal is saying that while Mr. Hazant still maintained that a different set of costs at the outset would have led to different P0 and or X percentages, blah, blah, blah.
Yeah.
So the suggestion was that a different set of costs would have led to a different P0 and or X percentages.
Yeah.
I'm afraid I can't remember what P0 and X are exactly.
I think P0 is 3% and X is 2.5, if I remember right.
2.5, I think.
Changed. I'll have to go back. Yeah.
They wanted to make it 3 and they made it 2.5.
I'm sorry. Yes, you're ahead of me, my lord. That's right. Yeah. Yeah. It's in 601. Yes.
Yes. Yeah, okay.
But again, we're in this tipping point territory. That's the difficulty with these things. Whereas what the tribunal majority is doing is saying, well, look, 1% is going to be very big in relation to a big number, and therefore we can rule that out. And what Mr. Besson said.
You might say the odds are you're not at a tipping point.
You might, but that's not what the tribunal's actually saying. Yeah, that's right. But I think it's also instructive if one just goes on to PC3, because what I'm trying to do is say what they were focused on was this what changes question, having made the mistakes they made. PC3 starts, the consideration of PC3 starts at 607. And this PC3 is important because it's 32% of the total overcharges attributable to this period. And again, what's said essentially is the process isn't fine-tuned enough to deal with these matters. But it's worth going down to 612. As a result of the failure to forecast loss of volume, Royal Mail's cash flow turned out to be some 3 billion lower than post-comment forecast, and this threatened financial stability. Clearly, this calls into question whether Royal Mail did in fact recover the overcharge costs. Mr. Besant suggests that Royal Mail's ex-post performance was irrelevant because it can't affect the only relevant question, which is whether price controls set ex ante would have been different absent the overcharge. Now, with respect, that is absolutely correct. And when the tribunal then goes on and says, however, we agree with Mr. Harvey that what happened relatively quickly after the pre-C3 price control was set shows that the assumptions and regulatory judgments that were made by Postcom were deeply flawed and indicates that the forecasts of Royal Mail costs and volumes were not fine-tuned enough to ensure that the minuscule increase in cost represented by the overcharge was reflected in the price control. Now, with respect, that does not follow. The fact that you get something wrong in a price control doesn't tell you, for the purposes of assessing a counterfactual, what the price control would otherwise have been. That's just a logical fallacy, and it's one that Mr. Ridyard specifically called out. So in relation to PC3, there is a clear error here in the reasoning. And again, what this reflects is the tribunal grasping at evidence which it thinks assists it in reaching this conclusion, having made a series of mistakes.
I'm sorry, I'm just going back to the structure again, because
Yes.
I hadn't got it properly in my mind. So we can see the P0 and X figures. But those are applied in relation to base costs.
Sorry,
In relation to base costs, what are
yes, cost and regulatory base, yeah.
so going back to 602 one moment.
Yes.
Are P0 and X necessarily crucial? Well, if the base costs change, then it doesn't matter whether your P0 and X change.
Not necessarily, no. There are specific discussions that are being referred to about the mechanisms by which you might have had a different settlement in the counterfactual, but it doesn't have to be only P0 and X that can change. But that was what was being discussed in relation to PC2.
Yes.
That's clear from that doesn't misrepresent what was being discussed in relation to PC2.
Sorry.
No. I suppose I should also just touch on the BT issues as well. Obviously, I'm not working through all of these points, but as you'll have seen from my reference to Mr. Ridyard's dissent, what Mr. Ridyard recognised was that where you had lots of price controls, glide path controls within the business, that the overcharge could make a difference. It was probabilistic that the overcharge made a difference to one of them. In other words, you did get a tipping point effect. And so you can actually get a weird effect where you can get more than 100% pass on in relation to these phenomena. But that's a separate issue. But this is dealt with by the majority at page 384, 659. The probability analysis is concerned with the rounding of the value of X in the glide path control. So effectively you can see the multiple glide path controls each as a sort of separate price control for a group of products for BT. Mr. Bazant's argument is that at some point the rounding would tip over into the next level, at which stage the overcharge, however small, would likely be recovered. On the face of it, the fact that Mr. Bazant is driven to having to make this sort of argument seems to demonstrate DAF's inability to trace the overcharge through into downstream prices, and therefore to be a long way from the proximity required to satisfy the legal or factual test for causation. Nevertheless, we'll explore it a little further. Now, I'm not going to comment on the degree to which that approach coloured the way that they look at the remainder of it. But again, there's a confusion here on law, because it's talking about proximity and legal causation. It's also talking about factual in the parentheses. But the fact that there's a complicated price control, which requires an expert to talk about some complicated stuff and do some probability maths, that in and of itself doesn't change whether or not there's good evidence to pass on. So to turn around and say, well, it's all a bit complicated, there are a number of price controls and you use probability, that shows that there's not pass on. As if pass on is necessarily going to be some kind of simple passing of geoplode bricks down a value chain that you can identify is just wrong. So again, it's showing how the mistakes of the majority coloured the way that they then considered these issues.
But, sorry, again, just to understand.
Please.
If the hypothesis is that you are only allowed to increase your prices if you have passed over a tipping point in this context, then working out the probability of your being at the tipping point surely does matter to the likelihood of the price being passed on, the charge being passed on.
Yes, it absolutely does, and here it does. But more than that, if we go on to 663, you actually have the probabilities calculated. So that's the point. Yes, it was complicated. That's the way that regulatory regimes sometimes are. But the fact it's complicated is not to be held against it as some kind of presumption, which is almost where the language of 659 goes. On the face of it, the fact that you have to go through this process suggests that there's a problem. It doesn't. And actually, by approaching it in this way, the tribunal failed to recognise the very high probability that actually there would be a tipping point with these multiple glide path controls. And if we could just go over to 667. In our view, this is wholly inadequate evidence upon which to prove that there'd been pass on, let alone 100% pass on, in relation to an overcharge attributed to Openreach. DAF can't show this actually happened, even if it is more likely than not that one or more charge control tipped. DAF can't show which one did and when it happened. Now, there's something very odd going on with the tenses of this analysis, at the very least here. But it's impossible to identify which downstream customers may have ended up paying the overcharge or who may have a claim against DAF. So again, we're back into the territory of saying, well, if you can't identify who the potential downstream claimants are, this is a further problem for us. It can't be said that BT's recovered the overcharge from others and so factual causation's not been established. Even if BT might have hit the jackpot at some point, that can't represent the recovery of the overcharge. And we don't think that could have been the intention of Ofcom as the way it would work. Well, the point is that these mechanisms did exist, and the question you're asking yourself is, how would they have existed if the overcharge wasn't in place? It's not a question of whether Ofcom had the intention of them working in this way at all. Speculating about those matters doesn't help. But again, it's just all of a piece with having made the mistake in relation to law and approach. They coloured the way in which they considered the evidence. So as I say, wrong on the approach to legal causation, took into account factors including these indicia far too heavily, and we see that then through the factual assessment itself. And we also see the errors in relation to legal causation rearing their head in relation to factual matters, which I've just particularly pointed to. And they applied an approach to evidence that was setting the threshold so too high, and in addition used the what changes test, which is, as we say, incorrect. The final thing I just need to deal with here is obviously Mr. Ridyard's coda. It's right to go to that, which starts at 728. So that's page 409. And what Mr. Ridyard is identifying is a range of policy concerns about how systems work. You'll see that what he's concerned about is whether or not the overcharge would be recoverable by somebody. But with respect to Mr. Ridyard, when you're dealing with a question of compensatory damage, that isn't the right approach here. And it's 731, he refers to the principle of effectiveness. This is not making the claim excessively difficult or impossible, applying these standards. And 732, I think it's obvious that there's a very high risk that downstream claims for any passed on damage in this case would indeed fail the effectiveness test. Individual claims would be far too small in value to be viable, and even a collective action on behalf of Royal Mail and or BT customers would likely face extreme difficulties. Well, that may or may not be the case, but competition law, post the modifications of the Enterprise Act and the Competition Act to allow for collective actions, are in many ways the one field of law where you have a situation where the legislature has taken specific steps to enable this sort of recovery. Now, the fact that in this case, as we were canvassing, you may not know precisely which the group are, is in and of itself not the answer here. So whilst Mr. Ridyard has perfectly legitimate policy discussion concerns, that doesn't change the question of how you approach issues of pass-on in a system where the key is compensatory damage. As he says at 733, he articulates the concern that if there's a substantial degree of pass-on, then a damages award that pays the full overcharge to the claimants involves overcompensation. And then at 734, he's coming up with possible ways of dealing with that. One will be requiring the claimant, allowing the claimant's full payment, but with some kind of set-aside mechanism. And the second would be making a full payment, but then requiring them to identify a certain proportion as credit. Now, if one is putting forward policy proposals for legislative schemes and changing the way in which competition damages claims work and moving away from a compensatory mechanism so that the claimants become essentially the representatives of society and then operate to disperse monies, then one can see that these sorts of suggestions might well be the sorts of matters you would consider. But that's not what we're dealing with here. And therefore, this does not provide any good reason why there shouldn't be, given the perfectly right findings, that it was more likely than not that there was substantial pass-on, that there isn't a reduction in the quantity of damage that is awarded against the appellant. And therefore, interesting though this material is, Mr. Ridyard's coda doesn't change the analysis. Unless the tribunal, the court has further questions, I'm sorry.
No, that's ground two.
That's ground two. I'm going to move on to ground three, if I may, just given time. So ground three is a much narrower, very specific issue for this case. It's the question is here about the value of commerce. In other words, the total value of the trucks bought by Royal Mail, to which an overcharge percentage is then applied, assuming that such an overcharge percentage should be applied and subject to pass-on issues. The case on ground three is that the CAT erred in including the price of bodies for trucks in that value of commerce. And that's because the bodies were not covered by the infringement, the settlement decision, and there was no infringement in relation to those, and therefore no overcharge should attach to it. This issue only concerns Royal Mail. It doesn't concern BT. BT's trucks did have bodies. Indeed, they have very sophisticated bodies because they've got all sorts of telecoms kit in them.
Yeah, because they were sort of open reach trucks. or whatever.
Exactly, but they don't. There are no claims in relation to those bodies. So, just as a starting point, I referred to earlier tractors and trailers. So those are the trucks where you attach a trailer to them.
Articulated lorries.
Articulated lorries, yes. And the alternative is a rigid truck.
Yeah.
And rigid trucks come in all sorts of shapes and sizes, engine sizes, cab specifications, and so on. And they have a frame upon which a body can then be attached. And
So
in
very
relation,
simple terms, DAF buying the bodies from other people,
so
attach them to the chassis or the frame or whatever, and sell the whole truck to Royal Mail.
well,
in
yes.
this account.
Interestingly, there were only 2 customers that DAF
Yeah.
ever sold trucks with bodies on.
Oh dear.
That was
Royal
Royal
Mail.
Mail and
I'm
Morrison's.
so sorry, DAF also manufactured bodies.
I'm going to come to that, Mr. Ward.
Yeah.
After 2007, they did manufacture bodies, and they didn't sell any of them to Royal Mail or Morrison's.
No, but they did sell them to BT.
No, they didn't sell any to BT. I don't think. I'll check that, but it doesn't matter for BT. There's no claim in relation to these matters for BT. So you've got rigid trucks, tractor trucks. We're only talking about rigid trucks. As your lordship has rightly identified, actually what happened was you had a whole different market of body manufacturers. This was actually a finding at paragraph 467 in the judgment. There's a separate market for bodies and trailers. And the tribunal actually found there were about 20 manufacturers of bodies and trailers on that market. And it's not contested. None of those were party to the infringement. In fact, it actually found that it's a relatively simple industry with more suppliers and lower market shares than in the trucks industry. That's at paragraph 502. So you've got these different types of trucks. You've got separate body manufacturers. And as I say, the trucks which are the subject to the claim, none of the bodies were made by DAF. Mr. Ward, who is my constant conscience on this, is right that after 2007, DAF did begin to manufacture some bodies. They are not the subject of this claim. It was a very small number of certain kinds of bodies, and they built them onto trucks. But Royal Mail didn't purchase any of them. And what Royal Mail is seeking to do, and what it succeeded in convincing the tribunal to do, was to treat the third-party bodies as part of the truck that was subject to the infringement, notwithstanding that for DAF there were only 2 customers that we sold these third-party bodies to at all. And the purchase of all these bodies, apart from those sold to Royal Mail and Morrison's, was directly from the third-party manufacturers. Royal Mail was exceptional, along with Morrison's in this regard, because what happened was Royal Mail went to the third-party manufacturer, obtained the body, and put it on the rigid truck in the factory.
So Royal Mail did, or DAF did?
DAF did. I'm so sorry.
In a sense.
I misspoke.
Very odd.
So,
Yeah.
I'm just confirming. It may actually be the case that the bodies that were provided by DAF were actually installed at the body maker's factory rather than the DAF factory.
Does it matter? Because the issue is whether the overcharge is in respect of only the tractor unit, as it were,
Or the rigid truck.
or the body.
It's the rigid truck, not the tractor.
The whole of the rigid truck.
And obviously, in relation to any other claimant apart from Royal Mail and Morrison turning up here, there would be no issue at all, because of course.
But there was no issue, is this right, in relation to the articulated vehicles, there was no issue that the trailers were not part of the infringement decision.
That's right. As far as we understand that there's
Well, those are probably standard anyway, aren't they? A lot of them are standard.
No, I think there's an awful lot of
Well, it's the cubic capacity or length of them often, I mean.
That's true. I mean, look, there are truck bodies and truck bodies, because
Yeah.
obviously truck bodies can cover everything from, some kind of emergency service vehicle that can be very sophisticated in its body, through the sorts of bodies that BT has, which are pretty sophisticated, can involve, bin lorries and so on, because the basic rigid frame will be the same. The bodies
I
you
was
put
also
on.
trying to think back to the sort of trucks that were on the road during the infringement period.
So, well,
I mean, in a modern context, there are definitely some extremely sophisticated vehicles you see, including Royal Mail vehicles with very high.
yeah. Well, I think those are ones that are essentially pushing the absolute limits of what's permissible as motorway for trunking services.
Yeah, I'm not sure those were around in sort of 2000 and.
But those are all tractor and trailer units in any event.
No, I follow.
So we're dealing, the vast majority of trucks that Royal Mail bought were much, much smaller. They were the smallest DAF trucks called LFs. And what we're talking about is a box body. It was a specific format of box body for Royal Mail, but it was a box body being put on.
Yeah.
If I may, I'll just go briefly to the judgment in relation to this. So back in tab 17, page 330. So the reasoning here is, I was going to say commendably brief, but it's only the brevity that's commendable. So the value of commerce section starts at 463 and sets out some numbers in relation to BT's.
What it comes down to at this point, as I read it, is that you didn't actually provide any evidence or information about any of this, and the tribunal concluded at 473 that DAF hasn't been able to show that the bodies weren't included within the infringement.
Yeah, well, there are two reasons at 473 that are provided. There's this failure to evidence how the cartel operated, particularly in this respect as to how it affected the pricing for the whole truck, including bodies and other options, which supposedly leaves us in the dark in relation to these questions. And then a suggestion that the settlement decision itself isn't clear, and that DAF did not clearly exclude, but managed to exclude bodies from its scope. Now, what I'll show is that the infringement decision is plainly only in relation to trucks and only without bodies, and it doesn't make any sense for it to go further. But I will very briefly, if I may, in 5 minutes I have, just deal with the first element, where this suggestion that we didn't provide evidence in relation to these matters is carrying over the mantra that the tribunal has, that DAF didn't provide evidence as to how the cartel operated, to a point where it ceases properly to recognise what evidence was actually provided here. And for that, if I may, I'd ask you to go to the supplementary bundle at tab 7.
What's your basic submission about the CAT's approach to the absence of disclosure?
It's neither relevant nor right. So there was a witness that explained how bodies were dealt with, how bodies were bought and priced, and what happened in relation to them. And I'm taking the tribunal to that. So the idea that DAF
I'm just wondering how we can assess their evaluation of the lack of evidence. I mean, as you say, this permeates a number of places in the judgment. They set out at the beginning of the judgment how claimants were allowed only to those documents which went to the settlement and nothing else. I mean, are we in a position to say that CAT got it wrong?
You are here, yes, because what you have is evidence that is not being referred to here, which does deal with the pricing for bodies.
Where's that then? Mr. Ashworth's.
Yeah, Mr. Ashworth. So Mr. Ashworth was DAF's managing director. And these are just extracts from his witness statement. So we start at page 50. There's a discussion of Royal Mail's truck requirements. And then if we turn over the page to paragraph 43, in the context of rigid trucks, he then describes both the nature of a rigid truck, but also the vast range of specifications and permutations that you could seek in relation to the rigid truck. And so there were a huge range of options that could be pre-selected in relation to the truck. As I say, engine, size, scale, cab, layout, all sorts of things. 44, the base chassis was still a drivable unit without the body. Generally, a base chassis had the lowest price for that particular specification.
Sorry, which paragraph are you in?
44, so I was just doing 43, 44, and then I was going to 45.
Yeah.
45, for rigid trucks, customers had to decide what body they wanted to put on the chassis. For Mr. Ward, before 2007, DAF UK didn't manufacture bodies. The customer therefore had to engage directly with the bodybuilder, or in some direct sales, DAF itself engaged the bodybuilder to perform the bodywork. This is what DAF UK did for Royal Mail, as I explained below. From late 2007, Leyland Trucks built some box bodies, but Royal Mail continued to get its from third parties. 47 articulates the range of further options that you could get when you ordered your truck. So you ordered your truck, it was bespoke, it was highly specified. There were a whole range of factory fitted options you could choose in relation to the truck. 51, so top of page 53, you'll see a Royal Mail LF DAF truck, just for illustration, with a body on. 51, as noted in paragraph 45 above, DAF itself engaged a third-party bodybuilder, and then the cost of that bodywork was included in the invoice to Royal Mail. For Royal Mail tenders, we gathered together all of the elements that made up the final vehicles to Royal Mail's specification, including third-party bodybuilder pricing. And then 60, describes the bespoke service being provided.
Yeah.
But it's just important. Bob Ford liaised with suppliers to assess whether the products were compatible with our trucks and negotiate the prices. We then fit these items onto the truck in our factory.
Sorry,
So-
where are you reading from?
I'm sorry, middle of 60.
Middle of 60.
Yeah, I'm so sorry. I skipped ahead.
Yeah.
My apologies.
Yeah. I suggest you come back to this in the morning.
Sorry, I was trying to hustle through
I
the
know,
evidence.
I could tell. and
Yeah, I was just trying to get
sometimes
through that. So because
more haste, less speed.
yeah, fine.
That wasn't intended to be critical, but
It's all fine.
it's been a long day as
Completely
well.
understood. I'm trying
It
to.
fades a bit at 4:30.
I don't understand how you can possibly say that in relation to truck body installation.
At least you have nice colour photos.
Yeah, I was going to say I finished on a photo.
Right, jolly good. We're not in any danger of.
I don't think so. I shouldn't be too long on this ground, and then
Okay.
groundfall will take me a little bit longer, but I.
Okay. All right. We'll say 10:30 tomorrow.
Great.
Thank you very much.
All right.